Welcome to Between Two Chairs, Demystifying Commercial Real Estate, the podcast that brings you the latest insights and trends on the South Florida commercial real estate market, with your hosts, Fernando Arencibia Jr. and Jennifer Woolman. In each episode, we dive into the world of commercial real estate and break down complex concepts to make them accessible for everyone. Whether you're a real estate professional, a curious investor, or just interested in the South Florida market in general, Between Two Chairs is the podcast for you. So pull up a chair and join us.
Welcome, everybody, to another episode of Between Two Chairs. My name is Fernando Arencibia, and with me, as always, is my resolute partner, Jennifer Woolman. Jennifer, say hi.
Hi, everybody. I love how you always have to try to come up with these words. Do you think of them ahead of time, or is it like on the spot?
It's all on the spot, but there's like a second of hesitation that I see in your face as to like, what is he going to say now? That I'm addicted to that. So it's just going to have to be
the deer in the headlights look from me like, oh gosh, well, now he has given me a couple of doozies that have left me a little bit questioning. But today we're super, super excited because we're interviewing Jennie Farshchian. She is the founding attorney of Farshchian Law, a multilingual law firm that focuses on real estate and probate transactions. And we're going to focus specifically on probate today for a bunch of different reasons that we'll get into in a little bit. But welcome, Jennie, and thank you so much for joining us.
Thank you so much for having me. I am excited to be here.
Great, great. So before we get started, tell us a little bit about yourself. What's your background? Where are you from? What made you found your own firm? And what made you specialize in real estate and probate?
So I really started out with real estate because of my own passion for real estate. I really enjoy real estate investing. I've been an investor myself for over 15 years now. Investing in commercial properties, multifamily properties, Airbnbs. So my husband and I, that's a big part of our lives too, is real estate investment, and that drove my passion to then focus on real estate law when I went to law school, and found that it really fit well together because with my investor clients, I get to learn so much from them on different investment strategies, different ways of doing things. In the world of real estate investment, there's so many different paths that you can take between, development, buy and hold. So it's really been a great experience just learning a lot from my clients as well. And then probate just ties in so well with real estate because when we're dealing with estates, usually real estate is involved. And then if the real estate has to go through probate, eventually the heirs typically do want to sell the property as well. So it just really ties in, well together. I've had my own firm now for, since 2011. So over 14 years now. And just a real passion of mine working in real estate. So.
Great. In terms of the probate side, well, first of all, let's get into the bare basics because we like to demystify, right? What is probate? What is what is the probate process? How does it affect real estate, etc.?
Okay, so probate is a court supervised proceeding that is brought in order to be able to change the title after a person passes to the name of their heirs or beneficiaries so that then they will be able to do what they want with the property, whether it's to keep it, to sell it, to refinance it. A lot of people think that if you have a will, that avoids probate. That's not the case. What avoids probate is how you title the property to begin with. So, based on if you hold it in a trust, that's one way to avoid probate. If you hold it as a life estate with your heirs being the beneficiaries, that's another way to avoid probate. When we're dealing with commercial real estate, a lot of times properties will be in the name of a company. will the shares of that company have to go through probate if the owner passes? That comes down to how is the company structured. If it's just one person and they pass, then yes, the shares of that company will have to go through probate before the heirs can sell. So it's really just about how is the real estate titled. Then we can determine, do we need probate? And then if we do need probate, what type of probate, so that we can get the property into the name of the heirs and sell as quickly as possible.
Okay. Is there a difference between how residential and commercial properties are treated during the probate process itself?
No, as far as that goes, there's no real difference.
Okay, so the process is the same whether it's residential or commercial.
Correct.
It's more how it's held, to your point, whether it's shares of a company going through probate or whether it's actually the title of the company from the deceased's name.
Correct. And a lot of
Okay.
people, even still today, you will see commercial real estate being held as an individual as well. And
Right.
if that individual is the only one on title, or they're on title with a couple of other people, but there's no what we call joint tenancy with rights of survivorship, like there's no survivorship language in the deed, that property still will have to go through probate. So it's really just looking at the deed itself, and then we know whether we need probate or not.
So, Jenny, for anyone who's listening who hasn't gone through the process, how long is that process of going through probate typically?
Okay, typically it depends on a couple of factors. One, when did the deceased pass? If the deceased passed more than 2 years ago, then we can go through the process of what's called summary administration, which is the shortened form of probate in Florida. When we can take advantage of summary administration, I typically like to, because it does save a lot of time and it also saves expenses for the heirs. It's less expensive as far as attorney's fees go. Now, if the estate's assets are $75,000 or less, we could also do a summary administration, even if the deceased passed less than 2 years ago. But when we're dealing with commercial property, we typically have, higher values than 75,000, right? When we're talking
Right.
about commercial values. So in that situation, if we do summary administration, it's usually because the deceased passed more than 2 years ago. And the timeline for a summary administration, I've done some in as little as a month and a half.
Wow.
And as long as 4, 5, 6 months, depending on factors like the number of heirs, the number of creditors, those kinds of things.
Right.
Now, the other type of probate, formal administration, that's when the deceased passed less than 2 years and the estate assets are over 75,000. We don't have any other avenue but formal, and that can take 3, 6, 9, 12 months, really depending on the number of assets, the number of heirs. But even within a formal administration, there's a process to sell real property so that you don't have to wait for the whole probate to finish before you can sell
Right.
the real estate involved.
Why does the court look at the time of death to be a contributing factor, whether you're able to do a summary administration rather than having to go to the traditional way?
That's a really good question, Fernando. It's because there's a law that says that most creditor claims are barred against an estate after 2 years has passed. So Florida law says that, like, certain creditors, like your credit card provider who's unsecured, that's an unsecured debt, a medical provider, they can't come after your estate after 2 years that you've passed. So therefore, we could do this shortened type of probate. Now, secured creditor, like a mortgage lender, they can always come after your property if you stop paying or your heirs stop paying. They can come 5 years later and foreclose. So that's how the state looks at it.
But isn't there always language, when you have heirs and you have somebody who has passed, past 2 years, they're still making the mortgage payment, but they're not technically on title. There is usually a clause in the mortgage documentation that basically will accelerate that debt if the title is not under the right individual. As a matter of practice, is that something that usually mortgage companies don't look at just because they're still getting paid? Is that how that works?
Because of that due on sale or acceleration clause, there's a law that came about. The Garn St. Germain Act is a federal law. And then that law has certain exceptions where a lender cannot call a mortgage due. And one of those exceptions is if a title transfers due to succession, like into, probate. So if,
Right.
because of like a death or succession, that there's a title change, the lender cannot call the mortgage due. And then there's like a couple other exceptions, such as if you deed to your spouse or you put the property in a trust that you're also a beneficiary of, a lender can't call it the mortgage due. So heirs have that protection. Now, if you're dealing with a reverse mortgage, though, it could get more tricky. But that's
right.
Yeah.
That's a whole other ball of wax there. Yeah.
Yeah. But good with commercial, you really won't be dealing with reverse mortgages.
Right. Exactly. Exactly. What is it in the process that you find takes the longest time? Is it the identification of the heirs, or is it making sure that any and all creditors are notified?
It could be both. When you only have like one or two heirs are usually not an issue, and people generally tend to cooperate because they want to get the money from, they want the process to go as quickly as possible. But, when you don't leave a will, it could get really, really tricky, the number of heirs that you have. I mean, I had situations where we have 16 heirs for one property because if you don't leave a will, Florida law dictates, or whatever state you're dealing in dictates who gets your property. And the law says that if you had a child and that child passed before you, their children now get the share of that child's inheritance. So let's say you had 2 children that passed before you, 4 living children. Those 2 children had 3 or 4 children each, right? Now those 4, now we have like 10, 12 heirs just because of that law, that per stirpes it's called, that, your child's share doesn't go to the other living children. It goes to their own heirs. So that's when you get things can get really messy. If you have a will and it says, well, I just want this, my office building at 123 Main Street to go to Jennie, then it goes to Jennie and we don't have to deal with 15 heirs. But creditors can also be tricky too, because you have to give them notice and then you have to see if they're going to pursue their claim. So that can definitely delay probate as well.
Oh my gosh, you just described like a nightmare for me. So how do you go about, and the reason I say this is, so I've had 2 of my parents have passed, both without wills and both owning real estate. Luckily I did know where all my siblings lived at the time. But how do you go about tracking down heirs, right? Especially in the case where there isn't a will.
So you have to do a diligence search. What the court wants you to do, a diligence search. And that involves, right now there's a lot of free resources out there like truepeoplesearch.com and, where you can put in somebody's name and then it'll show you their relatives. It'll show you their last known address, their phone number. And these searches are pretty accurate and up to date. So you have to do those types of searches. You have to call different relatives. It might even involve getting a private investigator involved to be able to track down the heirs. There's services that are just there for missing heirs. And sometimes it does have to come to that, especially you have heirs that live in different countries too, and you have to try to track them down. So it can, that could be a challenge.
I find, Jennie, and I'm wondering if you find the same thing, that most people don't understand how they are holding their real estate and what happens in the event of their death, or, when there's a big life event like that. What do you think accounts for that level of, I don't know if it's misinformation or just, general ignorance as to how their real estate is held and what happens after the fact?
Okay. Yeah, there is a lot of misinformation and there's just a lot of lack of knowledge about, how the property's title impacts, what happens to it after somebody passes. So I think it's important that people sit down with an estate planning attorney or real estate attorney that can, walk them through that and look at each property and how it's titled, and then determine, are we not only for probate, but also for asset protection? Like, are we structuring the titling in a way that we're avoiding, other creditor claims? Like, if I get into a car accident and somebody sues me, can they go after my, that office building at 123 Main Street? So it's also a matter of structuring properly to for asset protection and also for probate avoidance.
That's interesting. I know that the cost of fixing those issues before is significantly less than having to go through the probate, process,
Yes.
thereafter.
Yeah.
Can you speak to a little bit about that? Because, I know that this affects both residential and commercial. Most residential, buyers are not really, they got so many things on their mind. They got to deal with, getting the loan and, putting the money together. There's so many factors that sometimes the way things are entitled is not a big part of their priority. And some of those things just feel like they're automatic. They just feel like, well, the title company will take care of it, so they don't necessarily have those conversations.
Right.
I know in commercial is a little different, but to your point, I have clients that own significant commercial real estate under their personal name. There is an asset and liability that they have exposed themselves until somebody has alerted them to it, and then they made the change. But speak a little bit about how people can protect themselves in a reduced cost, really.
Yeah. And, when you talk about costs, it's important to know not only monetary costs, but also the emotional cost that comes with dealing with probate after the fact. It is a time consuming process. It is a process of having to deal with the court, having not only are you grieving and dealing with the death of a family member, but you're also, having to go through this court process and, deal with different heirs and their questions, their needs and all that. So you have to take all that into account. But you do also, as you said, like the cost of the monetary cost is a lot less. Probate, you're dealing with, several $1,000s at least to do a probate. While if you just, properly structure your assets beforehand, you're definitely going to save in that aspect. And I think it comes down to just creating a list of what you have. What are my assets? Even not just real estate, but like you could take a look at your, stock portfolios, your 401ks, and see, okay, like if I, do I have payable on death beneficiaries for those stocks, for those 401ks, where I, as soon as I pass, the funds are just going to go to that person and they don't have to deal with the probate process. And then with real estate, how can I title it? Yes, definitely to protect myself now. Because I have clients who they do own, commercial real estate, like you said, in their individual name. And they're like, oh, I have insurance. I have liability insurance that'll protect me. That's not always the case. Liability, like a lot of times insurance companies are trying to find ways to, reduce coverage or to not, cover a claim. And also you're still going to get sued in your own name. And then you have to hope that the insurance company is going to cover you. Right. Whereas if you put that property into a properly structured limited liability company or corporation, you at least now know that there's that asset has some kind of protection where people can't come out after your other assets that are not in the name of the company. So I always recommend have that company structure, set it up the company with an operating agreement. We could structure that in a way that also avoids probate. And then on top of that, get that liability insurance too. So you have that added layer of protection. And then for your own personal residence, a lot of us, we have in Florida really good homestead creditor protection. So your primary residence has protection against most creditors, not your mortgage or your HOA, but a lot of other creditors. So your primary, you don't have to worry about as much. With primaries, a lot of people like the life estate deed, where especially what we call the ladybird deed, where they can fully control the property while they're alive, but it goes to their heirs when they pass. And it avoids probate. So you could have, tons of assets and just title them in a way that avoids probate and also protects you while you're living against creditor.
We in this podcast always try to break down, some complex things because we want to really educate. One question that I get asked from people that are, let's say new to commercial investment, and they've asked me, why are some corporations incorporated in other states when they're buying real estate and they live in Florida? I don't know if you've had that, but can you speak a little bit about that? I know that is part, everybody talks about Delaware, and I've heard Alaska and other states that have some beneficial, legal, value to incorporating there. Can you speak to us a little bit about that?
Sure. So, Wyoming's another one, Nevada, that they have, or at least there's a perception, and I'm not a lawyer in those states, but there's a perception that those states have
Right.
a lot more business-friendly laws, like corporate-friendly laws, right? So when you look at the case law from those states, judges tend to rule in favor of the company versus like a creditor of that company. Or somebody who's trying to go after that company. So, Delaware has like a lot of that history and case law and it's now become where it's known as being very like friendly on the side of the company versus, other parties that might be involved.
Right.
So that's why people like forming companies in those states, even if it's holding Florida real estate. Now you might have to register to do business in Florida. So you can go on Sunbiz and, do that additional filing. So your business is a Delaware company authorized to do business in Florida. And then Florida also had some funky stuff that happened some years back where a person who was a single member of an LLC, so one owner of the LLC, was sued. And the LLC was sued, and the creditor was able to put like a charging lien or go after the individuals, distributions or something from that LLC. And then everybody was like, oh my God, single member LLCs in Florida are not good anymore. Like it just became a thing where it, created a little bit of stress on doing single member Florida LLC. So when we do Florida LLCs, we tend to have an additional member, even if they're like 1%. So it creates a multi-member structure. Where with a Delaware, you wouldn't really worry about that. A single member LLC would just have the same protection as other types of LLC, multi-member.
Yeah, and I think that we actually very interesting because we had that discussion, and I'm actually looking it up because I had drafted an email, but I believe that there was some case law that created that dynamic, right, between the issues of the single member and the multiple member, right? A Supreme Court case. Yeah. I know that is something that, it concerns a lot of us in the industry because a lot of our clients are single member LLCs and they feel that they have full protection and they're not understanding the nuance of doing that. And, I wonder if there is a place for our state legislature to address that, rather than to leave it open, where you have, a one member LLC versus a two member LLC, and all of a sudden the difference in protection is significant. Do you feel that is a need in our state?
It would be nice. I think it would be a good thing because Florida does tend to be very business friendly state, and they want to keep growing that and keep having people come and form businesses in Florida. So I think that would help, to keep people forming Florida LLCs versus, going to Delaware or other states just because they're concerned of that single member status.
Excellent.
So you already went through some of the ways that owners can have their heirs avoid probate, right? One is a corporation. The other is a ladybird deed that's only for residential, right? For your homesteaded property.
It should be only for residential because if you're renting a property or it's any kind of investment involved, I think it really should have a company type structure, even if it's residential or commercial.
Okay. So as a broker, how do I navigate selling a property that's subject to probate?
Good question. So there's a lot, various things involved. I think as a broker, if you are helping people with estate properties, first have yourself set up so that you're able to provide that service, that level of service that's involved with helping heirs. So what that entails is, one, educating yourself on the probate process. Okay, first, like, knowing that, is probate even needed? Because I think an agent or a broker, they have the skill set to be able to look at a deed and say, okay, I see, joint tenants with rights of survivorship language that avoids probate, or this is a life estate deed because it says to Jennie for life with the remainder to, and of course you can check with an attorney too, but it's good to have that knowledge to know, hey, I already know this deed doesn't even have to go through probate because of the way it's titled. And then understanding the types of probate, because of course they'll come to the attorney, but it's also good as the agent or broker to have that knowledge too of, oh yeah, this is a summary administration. This is generally like a 2-3 month process. Having that that knowledge of the basics of probate is important. So take a class on probate. Like I teach for the boards, and I teach a probate for realtors class. I think that would be helpful. To have a team set up of resources for the heirs. So, know a moving company that they could use, maybe a valuation company that they'll be able to use, a good probate attorney, on your phone. So like having those resources is really great, especially because we have a lot of heirs that are not Florida residents, right? They're like, mom owned a condo in Miami Beach, mom passed away, and now they have to deal with this property, but they don't know anybody locally. So they're relying on you to also, set them up with that team of trusted
So
people.
let me ask you, in that situation, the mom lives outside of the state but owns a condo here. Where does the probate take place? Does it take place here or in the state where she resides?
So
Or is it where the property's owned?
The where the property is owned always has to have a probate. So if there's Florida property, and let's say she didn't have any other assets that had to go through probate, but she owned that condo in Florida, that has to go through probate. But let's say she's from Kentucky and she had, a house there and a bank account there and a vehicle there, and they did have to go through probate. But she also had that Florida condo. We're going to have 2 probates. What's called the domiciliary probate, and then the Florida ancillary is the term for that, an ancillary probate, secondary. But because a court in another state or country doesn't have authority or jurisdiction over that Florida property, that's why you have to have, that second probate done in Florida.
Yeah. And you're so right about the team. I was involved in an estate sale. And I was able to connect the heirs to an auction company in the state of Florida that would come in and basically, because, there were a lot of things that didn't, there wasn't anything individual that had incredible value, but there was a lot of different things. And this company would come and basically give them a valuation for the whole thing and take the entire lot and then resell it as a lot. And it would help them because it would also clean out the property so that we could get it ready for sale. And those little things make you look like a hero because, you have access to that. You're giving them options and, and you're taking a huge, and to your point, there's an emotional component of, am I going to have to fly down to Florida, look at all of my, my family's stuff, and having to deal with that. So I know that that's an important component.
Definitely.
Some of our clients also have leasehold interest. So, for example, they might be a tenant in a 100-year-old land lease that they have redeveloped. They might still hold that leasehold right. How does that have to go through? Is there a way to avoid probate when you have a leasehold right to land that you want to, that has the ability to pass down to your heirs?
It's possible. Like if you could title that leasehold interest as, like, let's say joint tenants with rights of survivorship, like I hold it with somebody else, my mom or something, my business partner, right? Where if either of us passes, the other person gets that leasehold interest 100%, like, and then that avoids probate. That would work. Or if it's a married couple holding it, that we call that tenancy by the entirety. So husband and wife, if they hold that leasehold interest together. Or can the leasehold be held by a company and we structure that company's operating agreement in a way that, there's some probate avoidance? So
Right.
if the leasehold interest can be held in a different way than just individual ownership, I think that we
Right.
could structure in a way to avoid probate.
Interesting.
Yeah.
So in addition, navigating the sale subject to probate, having a team, understanding the types of probate, understanding the deed, anything else that you could think of if I'm listing a property subject to probate? Are there any things to look out for that can be an aha based on your experience where you've
Yes.
seen something that kind of comes up at the last minute? Or
I think a big one is knowing who has to sign your listing agreement and your contract. So I've had situations where we get to they list a property, because a lot of people actually, just to back up on that 1 minute, is that you can list a property, because I do have agents who ask me, can I list the property before the probate's completed? And yes, you can list it, but you have to make sure the proper people are signing your agreement. And so if you have 5 heirs, right, but we have a personal representative, and that personal representative was already appointed by the court, we can just have Jennie Farshchian as personal representative of the estate of John Doe be the seller on our listing agreement, right? You never put just estate of John Doe. We have to put people's names there. But let's say we don't have a personal representative appointed yet, but there is one named in the will. I would do Jennie Farshchian as personal representative of the estate of John Doe, and Gina, Fred, Sally, whoever, as all of the heirs of the estate of John Doe. And then I would make everybody sign, because the pitfall here is going to closing, right, and you're missing somebody who was supposed to sign your contract, right? So you don't want to be in that situation. And then if they don't want to sell, what do you do then? You're kind of stuck, and then it has to go through a lawsuit that we call a partition action, where the court has to basically be the one to decide and force the sale of the property. So you don't want to be in that situation. So knowing how to properly name the people on your listing agreement and also on your contract, so that you don't miss anybody, is a key factor. And again, come to an attorney if you're not sure.
Right.
Yeah.
If there is a will, and there's an executor of the will, would they sign, or would it be the heirs that are listed in the will who sign?
So if the executor hasn't been appointed yet, I would also make the heirs sign. I would have, Jennie as personal representative, and then Jennie, Joe, Gina, Fred, whoever it is, as all of the heirs of the estate of. Just to cover myself, because what if Jennie Farshchian can't be personal representative for some reason, right?
Got it.
Like, I was named, but for some reason or another, the court doesn't approve as personal rep.
Interesting.
And then you have homestead. So even with homestead, like, you would want all the heirs to sign. So there's different rules involving like homestead, non-homestead. If there's a surviving spouse, that they should sign. So you just want to make sure you cover all your bases and all the proper parties are named.
Yeah.
And they sign.
Yeah.
So just to finish this question and this thread of thought. So if I'm the listing broker, I'm going to go to you. And what do you need from me representing this property to help you help the probate process?
That's a great question. Yeah. So one, I would like to know, is there a will? If there is a will, who's named as the heirs, I would love to review that will. So having that will handy is great, in an electronic copy, so it could be emailed and I can review it. 2, we want to check also, does it meet the formalities that Florida law requires for wills? Like, it has 2 witnesses. It was signed by the testator, who's the creator of the will, at the end. The witnesses signed at the end. There has to be certain formalities. But also, I want to know, do they have the original will? Because having the original will means we save a lot of time and costs. A court assumes that if you produce the original will, meaning the version that is actually signed by the creator of the will, that will is valid because it's actually there. If you don't have the original, there's a presumption that that will destroyed or lost, right? Or maybe just like invalidated
Yeah.
completely, like revoked, right? And then you have to get people to prove it. You have to find the witnesses, and you have to track them down, and you got to make them do an
Wow.
oath. And so things get tricky. So I would like to
Interesting.
know in the beginning, is there a will? Can I see a copy? And do you have the original? Then I would like to know the date of death of the deceased, because remember when we talked about summary administration, if it's less than 2 years or more than 2 years, it makes a difference. And also I would like to know, is it their homestead or not? That makes a difference as well. So if the property is homestead, it could go through summary administration, even if the value is 75,000 or more, and the person is deceased for less than 2 years. Homestead is not considered part of that 75,000 test. It's called exempt property. So, a lot of times when, people leave a property, or it's their homestead, right? And then there's usually not much else that has to be probated. So it's helpful to know, is it homestead or not? And the heirs, who are the heirs?
Let me, I'm sorry to dig in the weeds with this, but I'm doing this because this happened to me twice with both of my parents. They died separately, and we knew they had wills somewhere, never found, not recorded, partial will that was only signed by the attorney, couldn't find the version signed by my mom and stepdad, couldn't find the one signed by my dad at all. The attorney who had done it had died. His heirs had sold the business. Like it was a disaster. So how do you, as somebody who doesn't want to put my kids through what I went through, right? And I own investment property and homestead. How does somebody go about getting a copy of the original will? Where is a place to safekeep the original will? I mean, I've already let my kids know everything about everything. They have access to everything, but I didn't know about the original will. So now I'm thinking, okay, I think I have a copy of the original. So my attorney has the original. So tell me a little bit about.
Sure. Sometimes people will leave it with the attorney, but again, like you said, the attorney might pass, his practice might close down. And I've had clients in that same exact situation where, the attorney's already passed away. I'm dealing right now with a probate that's a will from 1986. So, good luck trying to track down witnesses to prove that will. Thank God the heir has the original in that situation. So it makes our lives a lot easier. But I think definitely sending your children an electronic copy of the will, putting the original maybe in a safe or a safe deposit box, or just somewhere in a safe location, and letting the children know, hey, this is where the original is located. I think that's really important. But yeah, people do put it in a safe deposit box or a safe, or entrust it into the care of somebody that they know will keep it safe.
Okay, perfect. Thank you so much for that.
Sometimes part of the work that an agent or a broker representing a property that is in probate has to do is they will get asked to provide comparables and to provide basically a narrative of where the value was, how did we establish a value for listing the property, and then whether the offering or the contract that they want to accept, is it in keeping with the marketplace. But agents throughout use different formats to create a comparative market analysis or to do a brokerage price of opinion. What is your tip for anyone who is listening on how they should present that information to you, or to someone who is going to go through an attorney that is helping through the process, so that they can present it to the courts?
So not always do we even need, as an attorney, a comparative market analysis or an appraisal. Okay. Because if we do a summary administration, we don't need court approval. Therefore, we never have to present comps or anything like that. In the situation where we do need court approval, because we're doing a formal administration and, we don't want to wait till the end of the probate. Yes, we're going to need that comparative market analysis. Now, the courts, generally rely, as long as it's a recent date and, looks like a presentable report, they don't tend to question it too much. There's certain counties like Miami-Dade, if the purchase or the sale price is over $600,000, they do want an appraisal done. So in that situation, we'll need to get an appraisal. Sometimes, though, heirs, it's beneficial to get the appraisal because it also helps with tax purposes. So when you pass away and you inherit a property, we get what's called date of death valuation, or like that stepped up basis where instead of like your heirs having to pay taxes or on the gains from the day that mom bought the property, no, it's from the date that mom passed that we're, looking at the value of the property. So that appraisal might be needed just, for tax purposes. And that's another point, is that it's important that they talk to an accountant when they're going through this probate process to know what their tax liability or the estate tax liabilities may be.
Understood. So basically, if someone passed 3 years ago and they inherited the property, they might be thinking, well, we're ready to sell the property. It's been 3 years. We're going to sell it. They might be thinking, well, I'm not going to pay any taxes on this because this is an inheritance. But the court is going to look at, well, technically, the date of death was 3 years ago. There's been this, equity improvement from that time. So you'll get a value at that time. And then of course, the final value that you sold the asset at. And then you're going to pay taxes on that gain, right?
Yeah.
Is that? Okay.
That's accurate. And, I always tell agents too, like, if we're not tax professionals, right? I'm not a tax professional. You're not a tax professional. So just, the way you phrase things is like, okay, you may have that responsibility. You may have that obligation to pay those taxes. It may be date of death valuation. I never want to say, oh, you're going to get date of death valuation because maybe the way something was structured or, so just always preface it in a way that's not like, you're giving advice, but I think it may be this, but, talk to blank, they're a CPA, he'll know for sure, is what I always, I'm always careful myself. And I always tell agents too, because you just don't want to be like, caught where, but my general understanding is that, and you're right, that somebody might have passed 3, 4, 5 years ago. There might be significant gains between that time period. Right. And then the heirs may have to be dealing with that. So talking to that tax professional is super important.
And I would think it would be when I'm setting it up too, right? So if I'm the person who owns the property and I don't want my heirs to go through all this, I'm going to talk to a probate or estate attorney as well as my CPA to figure out the best move forward. So we need our team from the beginning, literally from cradle to grave of the transaction. We always talk about putting your team together. And that's one of the reasons we were so excited to have you on the podcast, is because we try to bring on people that can then create the team for our listeners. So we went through what I need if I'm listing as a broker, listing or selling a probate property. What if I'm a buyer buying a property subject to probate? What do I look out for? How do I represent my buyer as a broker? What do I need to know that I might not necessarily have access for because I don't represent the property?
Right. I think one, knowing, has the probate been started yet? Like, where are we at with the process? Are we towards the end of the process or in the beginning? 2, what type of probate are we going to be dealing with? Is it going to be a summary, which we know is going to be a shortened type of probate, or is it a formal? And then also, what, is my buyer buying cash or are they buying with a loan, right? Because maybe that closing date might have to be extended if we don't have the court approval yet, or we don't have the summary administration completed yet. And, is their rate going to change? Is there going to be issues with, getting approved for the loan? And also, what's their timeline? Like, are they moving from somewhere else and they have to get into that property quickly? Or is it like, okay, they have some flexibility? Let's say it's a commercial property. It's for investment purposes. And they're like, okay, if we close tomorrow or if we close in 3 months, it doesn't really matter for me that much. Or is it my office building that I need to move into as an attorney and it does matter to me? So timeline is also something to educate your buyer on, definitely. The process and the timeline.
Yeah. Well, I know we're getting towards the end of this episode. Are there any probate that you've gone through that has been the most memorable or the most complex to address? I know we didn't talk about this, but sometimes you have competing wills.
Yeah.
There are, so many things that happen in that scenario.
Yeah, oh, definitely. I would say the one I mentioned earlier was just one homestead property, but it's actually more than 16 heirs. We have about like 20 something heirs involved in that one. And
Wow.
it's still going on, I'd say 3 years later because of tracking down heirs, getting them to cooperate. Like it's just been a complete mess, just the number of people involved. And then I
Right.
have situations, which is interesting, is where you'll find an heir. I have a probate that I'm just trying to complete now. And the heir just wants nothing to do with the property. So we know where they are, but they're avoiding us. Even they don't want any part of the inheritance. Like they just want nothing to do with the other heirs, the
Wow.
property, the inheritance. And then you have to get usually a guardian appointed to represent their interests. And it adds a lot of different complexities. So we tend to like the, more straightforward where everybody's cooperating. There's not a
Yeah.
ton of people, but that doesn't always happen, and you
Right.
deal with the situation
Yeah.
you're given and you try to solve their
Yeah.
problems and get to the closing as soon as
Yeah.
possible. That's the goal. Yeah.
Yeah. And that's the other part, and you mentioned it earlier, but we're dealing with human beings that have complex relationships.
Mhm.
Sometimes they're estranged, and it bubbles up a lot of different emotions. And
Yeah.
I dealt with an estate sale, and it was 4 siblings. They lived at all different parts of the country. They were estranged from each other. 2 of them were estranged from the deceased, and it brings up a lot of that stuff. And I've heard attorneys have these conversations with them, and it almost feels like you become a therapist because
Yep.
you have to hear a lot about everything
Yeah.
that's going on, and he never loved my dad, and I mean there are some real
Yeah.
raw emotions that
Right.
come out of this. So
It's very
I know
true.
it's heavy lifting.
Yeah.
Jenny.
And then especially
Yeah.
situations where you have like prior children from a prior marriage. That's
Right.
another program I'm dealing
Yeah.
with right now. That's difficult where the surviving
Yeah.
spouse is not the mother of the children, of the deceased. So
Right.
that, creates issues
Yeah.
when they don't all get along. So yeah,
Yeah.
that's why.
Well, I'm wondering now with the DNA too, finding out about siblings that you didn't
Oh
know
God,
you
yeah,
had.
that's a whole nother can of worms.
So one of the reasons, and in closing, I like
Yeah.
connecting the dots. So one of the reasons, other than to have you and all of your wealth of knowledge for anyone who needs a probate attorney in their toolkit, is, Fernando and I talk a lot about demographics and boomers, which everybody pretty much knows that they're defined as Americans born between 45 and 64. So between the ages of 60 and 78. They own a huge percentage of the single family homes and properties in the United States. And for those of them who don't sell prior to dying, right, they're either going to have something set up so that their property doesn't have to go through probate, or they're going to have it ready so that it can pass, it can pass on to the heirs pretty cleanly. But what I wanted to get at is more the opportunity and the potential of this market, that I think more and more agents are going to start having to deal with properties that are going to be in some part of probate, whether you represent the buyer, whether it's your own personal family's probate, or whether it's a transaction that you're working on. Have you been seeing, you've been doing this, you said, for 14 years, have you been seeing more probate cases, less probate, because more people are informed on the correct structures? What are you seeing overall as a trend?
Interesting.
Based on solely my experience, which I don't know if I could speak for a statewide trend, but in my experience, there is a good influx of probate cases. People still don't seem to be doing that proper estate planning that they should be doing to avoid probate. And just with Florida being a very unique state in that we have so much foreign investment here. And so you also
Yeah.
have that factor where you have the, people from other countries that they just don't know either, that, putting it only in their individual name, if they pass, that's going to trigger probate, or that's going to trigger a higher estate tax. So I think in Florida, it's just very consistent, with and increasing, because people are just not doing that type of restructuring to avoid probate to begin with,
So
unfortunately.
if I have a foreign buyer buying here, how would I refer them to you or to an estate attorney? I know I would refer them definitely to a CPA to deal with the
Definitely.
structure, but
Yeah.
who else from an estate standpoint do I refer them to? Do you do estate planning as well as probate for real estate?
I tend to do, I don't tend to do anything for foreign nationals. They could get a lot more complex. I would refer them to an estate planning attorney that specifically works with structuring for foreign nationals, because of the
Perfect.
fact that foreign nationals have a very high estate tax threshold. So, when we pass as U.S. persons, we have 10 million of assets or more, that avoids estate taxes, and we won't have to worry. Like, our assets could be very high and we wouldn't have to worry about estate taxes. With foreign nationals, that's not the case. I think it's only $60,000 worth of assets. Everything after that gets taxed at 40%. So
Ooh.
because of the very low estate tax threshold, it's so important that they structure properly. So not only a good CPA, I would put them in touch with also an estate planning / corporate attorney, like a business law attorney, who could set them up really properly to make sure that they don't have to worry about that estate tax liability, especially if they own several assets here.
Perfect. Thank you very much. So at the end of our episodes, we always do a fun fact. So sticking in line with the baby boomers, I came out with out of the top 10 metros with the highest percentage of baby boomer homeowners, 3, our favorite number of those metros, are in Florida.
Oh, wow.
Number 2 is Tampa, St. Pete, Clearwater with 40.1%. Jacksonville, Florida is 39.6%. And I lost the percentage of West Palm Beach, Miami.
So Palm Beach is
Miami, Fort Lauderdale, and West Palm Beach was number 9 on that list of 10. And
Wow.
that's according to constructioncoverage.com.
awesome. Well,
That's
Jenny,
very
thank you so
interesting.
much for joining us. It's been wonderful, and I
Thank you.
appreciate you sharing your wealth of knowledge with us and joining us today.
And I wanted to thank you so much for being such an amazing Miami Realtors affiliate member.
Oh.
You are so supportive of everything that the association does and the education sessions that you put on so that our real estate brokerage community is more informed than most is greatly, greatly appreciated. I want you to know that we really appreciate that support.
Absolutely.
My pleasure.
All right, everybody.
Thank you so much for having me.
Of course.
Thank you.
Thank you.
All right, everybody. Thank you for pulling up a chair and joining us. And until next time, say bye, Jennifer.
Bye, Jennifer.